Hi, this is John Stark from John Reed Stark Consulting with my one big thing. Now that everyone's working from home, watch out for government requests and subpoenas seeking production of all electronic devices of company employees, including the ones they use at home and their personal devices. This is a complex issue that should not be taken lightly. For instance, the SEC routinely subpoenas hard drives and mobile devices, yet actually has no authority to do so. Moreover, it could be malpractice for a lawyer to produce to the government a hard drive or phone without first reviewing all the data on the hard drive or phone beforehand, especially in the places where deleted files reside, like unallocated space. Know when to push back. Stay safe and stay healthy.
Okay, welcome back and welcome to the final panel of the day, and it is a really good one. So the year of the whistleblower, somebody says that pretty much every year. They're usually right, but whistleblower practice just keeps on becoming more intense and more widespread. It seems to me like every week lately, the SEC is issuing multi-million-dollar awards to whistleblowers, but there's still plenty of confusion out there about what exactly is a whistleblower, what's the best way to handle a whistleblower from a corporate perspective. And this next panel is going to help clean that all up. Let me start by introducing our moderator, Brad Morosky, who's a managing director at AlixPartners. Brad's a CPA with 20 years of financial leadership and served for 6 years as assistant chief accountant in SEC enforcement. His experience spans a range of industries. He's built a reputation in particular in financial forensics around the globe. So welcome, Brad.
Thanks, Bruce.
Next up is Leslie Caldwell, a partner at Latham and Watkins. And Leslie was our keynote speaker in 2016 when she was the assistant attorney general of the DOJ's criminal division. Her illustrious career as a prosecutor also includes time as an AUSA in both the Eastern District of New York and the Northern District of California, as well as being the head of the Enron task force. But now at Latham, she advises companies and individual executives, boards facing crises or government investigations, and she can really offer a unique perspective on how companies should handle whistleblowers. Thank you for being here, Leslie. Welcome.
Thanks, Bruce.
If the topic is SEC whistleblowers, then Sean McKessy is the right person to talk to. And Sean is here with us. He was the very first chief of the SEC's Office of the Whistleblower. He built the foundation for that thriving whistleblower program. And now Sean's a partner at Phillips and Cohen, where he continues to fight for whistleblowers in the private sector. So welcome, Sean. As always, it's great to see you.
Bruce, thanks for having me and giving me a chance to put on a collared shirt for the first time in a couple months.
Glad to help. Finally, Alka Patel is the SEC representative on this panel. Alka began working in the LA office almost 20 years ago as a staff attorney and became an assistant director in 2009. She served as a member of the Division of Enforcement's FCPA specialized group since its inception in 2010. She also investigated and litigated a broad spectrum of significant securities law matters. And now as associate director, together with Kate Zolodz, who spoke earlier, she oversees the LA office's enforcement efforts in Southern California, Arizona, Nevada, and Hawaii. Alka, it's always great to have you with us. Welcome to this panel. Great to have you.
Thank you, Bruce.
Well, thank you. And thank you all. I look forward to the panel. And Brad, it's all yours.
Great. Thanks, Bruce. And thanks again for putting this on this year. Okay, well, we got a great panel. We're going to finish the day strong for you guys here. And I will say before we got started, the four of us were chatting a little bit, and we were trying to share some recent interesting trips that we've taken. And it was such a short conversation that I think we're gonna dive right into the content here. Truth be told, it divulged into Netflix shows that we've been watching that none of us want to share with anybody. But Alka, I'm going to throw it out to you first. The SEC program, the whistleblower program, has obviously been very busy recently. There's been a couple of notable awards issued just in April. It seems like the pace has really picked up. So maybe you can just give us the state of the program, any insights, any recent activities, focuses of the whistleblower program.
Thank you, Brad. First of all, let me give you my standard disclaimer that the views I express are my own and do not reflect the views of the Commission or the Commission staff. So yes, the whistleblower program has been a huge success since its inception, and it has had a significant impact on the enforcement program. We receive thousands of tips every year, and it has become an important source for our investigations and enforcement actions. And just to put that in perspective, to date, we've received about 33,000 tips, and just in the last fiscal year, received about 5,200 tips. Now, these tips come from all over the world, just like prior years, and also every state in the US. And they pretty much relate to every type of investigation that we have, including insider trading, market manipulation, FCPA. I would say that the main category would be corporate disclosure and financial reporting, and probably offering frauds. In the last, let's say, a year, 2 years, because cryptocurrency has become a new emerging area, we have also received quite a few tips relating to that. Obviously, awards is the most critical component of this program. So let me just talk a little bit about that. To date, we've paid out about $450 million to about 82 individuals, and we've had some really large awards. In prior years, you've seen we paid out about $50 million to 2 individuals, and then just recently, in the last couple months, we had an award for $27 million to an individual. So I'm just talking about these recent awards. There's been a lot of activity in the awards, as people may have seen, and there's been a lot of speculation and perhaps questions about them. And actually, the answer is pretty simple. We've been, from a while, we've been saying that we are working to improve the claims evaluation process, and we've been doing that from the last year or more. We've streamlined the internal processes, and we're doing a much better job coordinating among the Division of Enforcement and the Office of Whistleblower and other divisions. And what you're seeing is the result of all of those efficiencies and the streamlining. So we hope that as we continue improving our internal process, there's going to be more and more progress in this area. But then I also want to talk a little bit about whistleblower protection, because in addition to incentivizing whistleblowers with awards, we are also continuing to focus on the protection, because frankly, the two things go hand in hand. Where the whistleblowers need protection is basically where employers either retaliate against the whistleblowers because they reported misconduct to the SEC, or employers and other people, other persons, I should say, put pressure on the whistleblowers or the prospective whistleblowers to not even come forward and report any misconduct. And this we see in the form of provisions in settlement agreements or confidentiality agreements, where employers will prohibit the individuals from even communicating with the SEC, or including provisions where they may have to give back any whistleblower awards they may receive. So which all results in whistleblowers being afraid to even come forward. And so this is an important area for us. It's a high priority area. And so we are continuing to bring cases in this area. And a recent example of this has been the Collectors Cafe case, which was a online auction company, and its CEO. And we initially filed a complaint against the defendants for offering fraud. And then later we learned that in the course of the company trying to resolve the disputes with the investors, they were forcing the investors to sign settlement agreements that had provisions prohibiting them from communicating or cooperating with the SEC. So we amended the complaint and added more allegations relating to the anti-interference claims. Actually, the defendants even went so far ahead as to sue to a couple of the investors, claiming that they had breached this agreement. So that was pretty egregious. And so we moved quickly to amend the complaint. So that basically, gives you a little bit of an update on where we are and the status and the trends in the Office of the Whistleblower.
Since we rehearsed this, I think Brad was about to ask me about the proposed rule changes that are pending. And while hopefully we figure out the microphone issues, I'll take the floor for a bit. So the SEC has proposed changes to the whistleblower program. I think the changes were proposed a little over a year and a half ago or so. I think it covers a lot of ground, and we only have a limited period of time. So I'm not going to go through all of the proposed changes, but I'll highlight a couple that I think most people who represent whistleblowers feel are positive, and then a couple of more controversial ones from the whistleblower bar perspective. One of the more straightforward things is the proposed rule would implement the Supreme Court's finding in Digital Realty, which found that an individual who does not report to the SEC is not entitled to the Dodd-Frank anti-retaliation protections. There's some legislative initiatives to see if that decision might be overturned, but for right now, the proposed rule would implement what Digital Realty said, which is a reversal of what the Commission had felt in the past, which is people who report only internally should still be entitled to anti-retaliation protections. But leaving that aside, the two aspects of the proposed rules that I think most people would find to be helpful, and I suspect Jane does as well, are efficiency building changes. One would allow the whistleblower office to have what I call summary disposition power. So in an instance where somebody submitted a tip and that tip never got out of triage, and somebody applied for an award, and it's clear that person cannot be entitled to an award because enforcement staff never worked with that person, the whistleblower office would be able to issue what we call a one-pager, just a summary disposition. Without this change to the rule, every application has to go through a very thorough due diligence process where the whistleblower office has to make a recommendation to senior members of enforcement, which is called the claims review staff, and then elevate that recommendation to the commission. And that can be a very time-consuming thing, particularly when once something comes in the door, it's not going to go anywhere. But there's no way for the whistleblower office now to have that summary disposition process. So I think that would be a very favorable tool. The CFTC has that power, and I have heard from the head of that program that it has been a very effective way for them to streamline a lot of work that would otherwise have been necessary. The second has to do with what I call serial submitters. These are people who every time a notice of covered action is posted, they submit. So if 10 notices are posted in a given month, these people would submit 10 applications for awards, even when there was no connection to, or they never provided any tip in connection with it. And the rule change would allow the whistleblower office, again, without having to go through the commission process, to permanently bar anyone who submits 3 bad faith applications in a row. I personally think it should be 2 because in America we think everyone should get a second chance. But the idea is, on my watch, we kicked 2 people out of the program permanently, but both of those took a very long time because there was no rule, and so I had to rely on the statutory language and rule about bad faith, which required a lot of time building a record that it wasn't an easy thing as the head of the office of the whistleblower to go to the commission and advocate for people being kicked out of the program permanently. So we had to make sure that we prepared a very lengthy record. This would allow that kind of thing to be eliminated. And, I can say that we had a tough time getting a lot of money out because the serial submitters were attached to every single application. and we were not allowed to pay people until everybody's due process had been exhausted. So I think that's a very positive development as well. On the more questionable end of it, from those of us who represent whistleblowers, there is a financial impact proposed change. Some call it a cap, some call it a ceiling, some call it a floor. And the odd thing is that everybody's kind of right. It's a little bit of an odd bird, but in essence, it would allow the commission to take into account the size of the pot. Right now, that's not one of the considerations that is permitted. And what the whistleblower office and the commission under the current rules is to take into account is how good was the whistleblower, how good was the information that he or she provided, did it help you bring a really good case, and then there are some negative factors. What specifically was not allowed when I was there under the current rules was to say, well, because this person is going to get a big amount, a big award, we'll shift the percentage down to closer to the 10%. Rather than 30%, even if the whistleblower did everything exactly right, exactly what they wanted. And this just injects some uncertainty into a process that shouldn't have it. And my view is that, the program, I appreciate Alka's remarks, and I agree with what she said, and it's kudos to the enforcement staff and the whistleblower office. The program is working really well, and to inject this level of uncertainty, and I now have to go to a client and say, the statute says you can get 10 to 30%. And if you do everything right, you should get 30. But if you help them bring a really big case, they're going under this new proposed rule, they may have the ability to say, even though you were the perfect whistleblower and under any other circumstance, we give you 30%, because you helped us bring a really big case, we're going to lower your percentage because, and the other problem with this proposal is it has a very amorphous kind of what is reasonably necessary to compensate this whistleblower. And, that is a very amorphous standard, and any given group of 5 commissioners will have probably a different view on it. So that is viewed from most of our perspective as being an anti-whistleblower proposal. And then the second one has to do with clarifying something I'm not sure needed to be clarified, which is the definition of original information, and which under the current rules allows for what they call independent analysis. So this is people like Harry Markopolis, who are reporting on companies they never worked for, but have market information, and maybe it's all public information, but they submit what's called an analysis, and allows the commission to bring a case. And under the current rules, if somebody provides good independent analysis, and I know that we paid several of them on my watch, they're allowed to be paid under the program just like as if they were insiders, as long as their analysis was independent and wasn't solely didn't clip an article from the Wall Street Journal and send it in and say, now pay me when you're done. It had to be, thorough analysis. The wrinkle that this new proposed rule injects, and again, I'm not sure why it needed to be clarified, but it would, in essence, what it says is a person who submitted independent analysis, in other words, not firsthand knowledge, would be deemed to have original information. And here's the kicker: unless the commission decides that the staff would have figured out what the person submitting the independent analysis was, and by the way, it's not that the staff did open up an investigation or the staff did figure out what was reported by an independent analyst. It's that could they have figured it out? And in my mind, this creates all kinds of uncertainty that we don't need. I know Harry believes that although the proposing release goes out of its way to praise Harry, I think he believes it's taking the complete motivation out, because if you think about it, 2 things are off about it. One, nothing is, let me put it the positive way, everything is obvious with the benefit of hindsight. So to be able to, to ask to impose a standard and say to an enforcement staff member 4 or 5 years after the fact, could you have figured this out without this whistleblower coming forward? There's nothing that, factually that you would say, no, I wouldn't have figured it out. Once things happen, like, for example, if a pandemic breaks out because of however it broke out, we now know that that's a problem. We wouldn't have predicted it, in February or January, but we now know, and now it seems obvious, all these things. 9/11 seemed obvious, very shortly after it happened. So that's one problem. The second problem is it puts enforcement staff in a tough spot, because now, again, 5, 6, 7, 8 years after the independent analysis came in, you're asking an enforcement attorney, would you have been able to figure this out on your own? And is there a single, I was one of them, and I love all the enforcement attorneys. I can't think of a single one who would say, no, boss, there's no way I would have figured this out, except if unless the whistleblower came forward. So as a practical matter, it takes all motivation out of anybody who wants to provide independent analysis to do it. So I hope that, I know that there were robust comments around these proposed rules, and I hope that we move forward with the ones that will help what is already a really good program, and take a really strong look at the things that are injecting some level of uncertainty that I don't think is merited.
Can you hear me okay now?
Yes.
Oh, good. Thanks, Sean. I mean, that's such an interesting point, though. I mean, what do you say to the folks that say, well, the SEC is effectively outsourcing investigations by allowing for that?
By allowing for payments?
Yeah,
or
payments
independent
for just based on analyses and not based on individual information that otherwise wouldn't be made available.
Well, I guess I would say that, Congress decided when they passed Dodd-Frank that there were a number of things that needed to change. And we can debate whether, if the whistleblower program was in place, whether the financial crisis that gave rise to Dodd-Frank would have happened or not. But at the end of the day, I think Congress, in passing Dodd-Frank, said Sarbanes-Oxley, which counted on internal reporting structures, didn't work. And we need to do more. We need to provide enforcement staff with more tools in their quiver. And one of them is to encourage people like Harry Markopolos to come forward. And there's no reason to say that those folks ought not to be rewarded just because their information didn't come from firsthand knowledge. Because let's face it, the enforcement staff can't know everything and be everywhere. And I think, I know for a fact that we paid a number of whistleblowers when I was heading the program, and because they provided a very valuable service, and they analyzed things that were generally publicly known, but they had, analysis that made it easier to understand why there was a violation here, even if it was based on publicly available information. So I think it's a little bit of a red herring to say that this is outsourcing the enforcement staff's job. The enforcement staff has to take the analysis and run with it and build a case. But when the program was created and the rules, the original rules were passed, I know, the intention was to try to make the tent as big as possible and to get as many people who may know things that will help the enforcement staff stop fraud, prevent it from happening, or stop it before it gets worse. And, it seems very counterintuitive, when you have a program that seems to be working pretty darn well, to now start closing that tent up and say, we're not going to let certain people in the tent. And by the way, if you help us bring, the next Enron, or bad example, but the next case where there's hundreds of millions of dollars in fines collected, we're going to treat those people who helped us bring those cases worse than people who helped the staff bring lesser cases by saying, we're going to reduce your percentage because, it's enough money already. You don't need to have more money. It's just it's counterintuitive to me. And I know a lot of us who represent whistleblowers think so as well.
Got it. Thanks. Leslie, I want to actually piggyback off that and address something. And then after my question for you, I want to circle back. We've had a couple of questions come in through the chat. But just going off of what Sean's talking about, Leslie, I know we were discussing a little bit before our panel this newer, I'll call it a newer phenomenon now of companies effectively receiving letters from what I'll call whistleblower counsel type firms, raising certain allegations and also alluding to the fact that they're going to, and these letters are getting sent to the audit committees and the boards and, the people with governance oversight responsibilities. And they're also CC'd to the SEC and in some cases the DOJ. So that creates a whole lot of considerations for people advising those companies. So what are your thoughts on some of the implications that companies need to consider with respect to self-reporting, investigating these allegations? Love to hear.
So I don't know how much, if any, of the what I'll call an uptick is attributable to digital realty, but there certainly does seem to be an increase in those letters coming across the transom. And as you said, Brad, you're right. They usually are addressed to the audit committee. And they're usually CC'd to the C-suite executives, including the CEO, the general counsel, et cetera. They are of widely varying specificity. Some of them will, and they tend to be in the FCPA space, at least in the ones I've seen. They tend to, they may say anything from company X is paying bribes in country Y without any further detail, which there's not a lot you can really do with that. Or they may be extremely detailed and describe in detail transactions that are supposedly the subject of improper payments. They'll lay out the parties involved. They'll lay out the dates of the deals. They may even lay out like the internal company tracking numbers of the transactions, which makes it a little easier to look into. So just as with any other internal whistleblower allegation or hotline report or anything, you're not going to automatically investigate every single thing that comes across the transom. The more detailed letters will tend to tell the company what it should be doing. So you must look at person X, Y, and Z's email, and you should make sure that you get person X's phone before he has a chance to know that you're coming for it. And you should interview the following people, and you should do this and that. The company obviously is not going to just take the advice of some anonymous whistleblower whose lawyer wrote a letter, but you do have to at least, especially in the more detailed ones, you have to at least kind of kick the tires a bit and see, is there any there, or is there anything that sounds similar to this that you can identify? Another question is, since they're CCing, and they do CC the SEC and the DOJ, since they're saying they're doing that, should you contact the SEC and the DOJ? And my answer to that would be generally absolutely not, at least not when you first get the letter. You can assume that, and Alka, maybe you can answer, where did these letters go? If there's already not an investigation open into this particular company, where within the SEC does a whistleblower letter say alleging FCPA violations? Does it go through the usual process, or does it go to the FCPA folks?
Look, I mean, as far as we are concerned, it's a tip, and we give the same scrutiny to all tips. But of course, some tips are very generalized. As you said, you're not going to open an investigation into everyone at the corporation level. And it's the same for us. If the tip is so generalized, so vague, cannot be corroborated, does not include any firsthand information or witnesses identified, then it's essentially a fishing expedition, and we generally will not go there because we are good at evaluating the credibility of whistleblowers. I mean, there are some presentations that come to us that are very credible, very detailed, and we know that this is something that we can or should pursue. And then even at the stage when we talk to the whistleblower later ourselves, we're still determining the credibility, and we reassess at every stage. So I don't think people should feel that just because a letter has been sent to the SEC that there's now going to be an investigation. Obviously, we are going to look at whether it makes sense. We also have limited resources, and we get a ton of tips, and we got to pick out of those tips and make sure we are pursuing the right kind of investigations.
Do you tend to give more credence to tips that come, say, from a law firm than from an individual reporting party?
I think we look more at the content. And, you know, as I said, if somebody has firsthand information, that is obviously more credible. There are some whistleblowers who don't even work at the company and heard about something, some kind of a rumor through some third-party source. Obviously, those don't get as much of our attention. But we find that the reputable law firms do vet the whistleblowers maybe a little more, and that's why maybe we're able to find more credible information in those complaints. It's not because they are represented by counsel, but maybe some counsel are better than others at picking the right whistleblowers and sending us a complaint. So it's really a content evaluation rather than whether it's a law firm or not.
And I've seen that a lot of these letters allege FCPA allegations and kind of target companies that use intermediaries in third countries. For example, say in public sector deals, there may be a law in the country that requires a local company to be in the tender process or in the sales process. There may be credit reasons why a company might want to use an intermediary, so that if a government agency only pays every 6 months or 9 months, they may want to be paid sooner than that. But the letters that I've seen tend to focus, and I don't know whether the Microsoft case had a whistleblower, and I'm not asking you to comment, but cases like that, where they're middle entities. And so that's, I think, fallen heavily on, for example, technology companies. It may just be partly because I'm in the Bay Area, but I think that's an issue for a lot of technology companies. And so it's really hard to decide, how seriously to take this. If you kick the tires, I think you tend to treat it the same way you would treat any other allegation, but you do have in the back of your mind that the SEC and the DOJ know about this. Whether they've really focused on it or not is hard to tell. I think the harder thing is if you're already under investigation and you know that by the SEC and the DOJ, and you get another letter that's about something totally different, let's say an FCPA allegation and completely unrelated geography, what do you do with that? And I have a question for you is let's say that company's cooperating in your existing investigation, they receive a letter, they don't tell you about it, and then you find out about it. What are the implications of that from the SEC's perspective?
Well, I mean, again, it depends on the nature of the allegations. If it's just some anonymous individual just basically saying, hey, I think there is bribes going on in Kuwait or something like that, I think that's different than something a little more substantial. But if at all we do find out that the company knew about it and didn't say anything to us, then that goes into the mix for the cooperation credit. And that's how we would handle that.
And then I think another tough issue in this involving these letters is if you do an investigation, internal investigation, you have to decide if, let's say you find out that the allegations are true or close enough to true, you have to decide whether you self-report or not. And I think the X factor in this is that you have reason to think that the SEC already knows. It may not be the FCPA person at the SEC who already knows, but I think that's a really difficult decision because in the normal investigation, candidly, part of the calculus about whether to self-report is what's the likelihood that the government will find out about this. And I think in these situations, you don't have that luxury. Of course, it could slip through the cracks, but I'm sorry, go ahead.
No, what I was going to say was that this is the reason why the whistleblower program is so critical, because the companies don't know whether we know about it, right? Because at any point, any whistleblower can give us information. So if the company knows about something, it is in their best interest to self-report, because as we keep saying again and again, there are significant benefits to self-reporting and cooperating with the SEC. And you don't want to take a chance that some whistleblower is going to report to us and the company has not told us about it, because that will then, if you think about an FCPA case, which has huge monetary sanctions, it makes a huge difference whether the company gets cooperation credit or not. So that's why we are always obviously in favor of self-reporting, which I'm sure you don't agree with me, but
I used to, but I don't anymore.
Yeah, the calculus about whether to self-report is a complicated one, right? I mean, I worked in-house at 3 different companies in between my SEC stints, so I'm not oblivious to that. But I do think, unlike Leslie, the example you gave, where the company's on notice that they've CC'd the company, you don't have to wonder whether the SEC is aware of it. Now, you don't know whether they're taking it seriously or not, but at least you know that the SEC has been informed of whatever this is. What's more complicated, and again, from my perspective, I think, as Alka said, a benefit of the program is when you're doing that calculus of whether you should self-report, you have to consider whether there's a whistleblower out there. And that may, in some instances, all things being equal, and you think there may be a whistleblower, that may change the calculus. It would just be naive for people not to at least consider the fact when they're thinking about, and I get it, sometimes it's better to just whistle past the graveyard and hope that nothing comes out of it. But in making that determination, you have to wonder about whether someone has reported it, and and that's obviously going to have implications if you decide not to self-report.
Right. No, it's a very difficult decision. I think it's probably one of the hardest decisions for companies when they're thinking about what to do about some internal wrongdoing.
For sure.
Yep. Yeah, not made easier by the existence of the whistleblower program now. maybe Alka, let me throw out a question to you that came through on the chat. As you were talking about employee protections under the whistleblower program, a question came in regarding vendor protections, and if there are any vendor protections that would be similar in nature to the employee protections if they wanted to blow the whistle.
I just want to clarify, when you say vendor protection, you mean like having provision, like prohibiting vendors from coming forward?
No. I'm sorry, to actually protect vendors that may want to blow the whistle on one of their customers for unscrupulous behavior. Are they afforded any protections under the whistleblower law?
Well, we have not come across that situation, but as you've seen from the cases that we brought, we are not focusing only on the employer-employee relationship. The case that I just talked about, the Collectors Cafe, that involved the company and the investor. So it's not necessarily an employer-employee situation. So I would think that this can be expanded beyond the employer-employee relationship.
Got it. And Sean, I'm going to throw the next question to you. To the extent you've got any insight, one of our guests has commented that there is some pending legislation in Congress for the PCAOB and a whistleblower program that would, I gather, would be similar to what the SEC has. And if you have any thoughts on that, and particularly the implications on the auditor-client relationship that could create.
Yeah, I mean, I don't want to be flip about it, but as someone who practices in this space, the more programs where people get paid, the better, from my perspective. So I'm happy, and I believe that when properly run, the programs can do a lot of good. It does get very complicated in the PCAOB context, and this is something we wrestled with, in proposing the rules for the whistleblower program. Should internal auditors or external auditors even have the possibility of getting paid? And there were very strong opinions that there should be a per se ban. No external auditor should ever be eligible for doing what they're supposed to do, which is audit the company. And if they find wrongdoing, they don't run to the regulator. Ultimately, the SEC rule came out to not have a per se ban, but it's a very thin window that will allow people in the audit context, if they should have reported it or had an obligation to report to the SEC under Cap A, 14 Cap A, I think it was. And so you can envision a way to maybe structure it so, but it does create some additional logistical obstacles when you're dealing with a regulator that's focused entirely on the auditing of the big audit firms. But I encourage the thought exercise, and if there's a way to do it and thread that needle, because we count on those auditors. We all do. Everybody who invests in a company really counts on these auditors to make sure they're doing their jobs. And if there's another mechanism that can make sure and support that, then I'm for it. But I understand it's a very difficult walking of a fine line.
Yeah, I'll reserve my opinion. I can see a lot of pitfalls with that from the auditor-client relationship standpoint. I guess one thing I wanted to touch on, Sean, and I'll be mindful of the time because I know we're real close to the end here, but if you can quickly summarize how you assess a potential client, who's a good client as a whistleblower, who's a bad client, any thoughts there?
Sure. So, I mean, it hasn't really changed that much since I was heading the whistleblower office. People would ask me, what should we be looking for? And, it's the general criteria. I want specific, timely, and credible information, from somebody who has a reason to know what they're talking about. I do not take on every client that comes in the door, and I wouldn't take on a client who said that they want to immediately write to the company and CC the SEC. That's not, my role is to help people who are interested in reporting to the SEC and navigate the process to do so. So when you go through each one of those, specific, you can't have, as Alka said, just a generalized, I heard that there's bribery going on somewhere. You want to have very specific information. It has to be timely because the SEC's resources are are scarce, and they're not going to want to open up a case that from conduct in 2005. It has to be, and then there's statute of limitations and all that, and credible. And you assess credibility as we all do. You look people in the eye, you meet with them, you ask them questions. How are you in a position to know this, and what other information do you have? What other documents do you have to bolster yours? And if you don't have all that, then I'm not going to move forward. I guess the only interesting additional thing that I now have that I didn't have when I was heading the office, I wanted every good tip to come in because I wanted the enforcement staff to go. Because I work for a contingency firm, I also have to ask myself, is this, no matter how great it is this the kind of case that the SEC will get over $1 million in sanctions? So there's a business consideration that I have to put in as well. And I have had instances where I thought the tip was great, but I just didn't think it was going to get over that threshold. So, but you're looking for the big game in my space is you got to get tips out of triage and into enforcement's hands, and with thousands and thousands of tips coming in, I want to have the winning ones. I want to have the most specific, the most timely, the most credible, and I want to provide as much analysis so that it makes the enforcement staff's job as easy as possible, so that they'll take it and they'll run with it. I also spend a fair amount of time pre-selling my tips. So I'll call somebody, if I have an FCPA case, I'll call one of my former colleagues in the FCPA unit and say, look, I can't give you the names right now, but here's the general allegations. Are you interested? And that can help expedite the review process and get it in the right hands. And that's a big part of what I do as well.
Got it. Yeah, no, you just preempted my next question is there a calculus to which office you report to, which individuals you necessarily may take a tip to? It sounds like the answer is yes.
Yeah, so, I think it's having worked with the Office of Market Intelligence and knowing a little bit on how the allocation process works, and it's not perfect. I have a sense, sometimes it's geographical, sometimes it's specialty unit, sometimes it's frankly, if it's a complex thing, I'll call somebody in this CFI, in this complex financial instruments unit, and say, this is really complicated. Do you have any, interest in it? And, sometimes if I don't know, I'll just call, a former colleague and say, who's the best person, to try to steer a real estate investment trust tip to. And I'll take the advice of one of my former colleagues who will say, listen, that's not my thing, but I know you should talk to so-and-so.
Well, Alka, I know I'm going to ask you real quick. I know the easy answer is that the SEC is concerned with any potential securities laws violations. But I'm going to ask a more pointed question. Honestly, is there a calculus given to the nature of the allegation when deciding how much attention to give to it? If it's a financial reporting whistleblower complaint, and there's a big appetite at the commission in the current period for those types of cases, does that receive a higher level of attention than an insider trading complaint necessarily would?
I don't think so. I think that we would give the same scrutiny and attention to any kind of a case. As you know, we bring all kinds of cases. We are not limited to any one particular kind of case, and there may be at a given time maybe perhaps a priority to bring perhaps let's say the ICO cases or right now the COVID related cases, but that doesn't mean that we stop doing everything else. So it doesn't matter whether the tip is relating to financial reporting or insider trading. Every case is important, and if the allegations are credible, then we will pick it up and pursue it.
I would say, too, just from a practitioner standpoint, I do pay attention to what the SEC is focusing on. And, there's no better way to, if they form a new unit or new task force, when the cyber unit came up, I look more closely at the cases that I know that the SEC is looking for. And I will be looking for people coming forward with COVID-related tips because I know that's a priority. Cybersecurity, ICOs, I know that's a priority. Doesn't mean I don't take other kinds, but it helps bring it to the front of the queue for my analysis because I know it's something that again it's a competition to get your tip considered, and when it's a priority, that can help get your tip into the right hands.
Well, Alka, Leslie, Sean, thank you very much. I see our master of ceremonies is back in, and he's told me that he's buying the first round of drinks for everybody tonight. So,
yep, drinks are on me. Hey, thank you, Brad. That's our last panel of the day. I told you it was going to be a good one. Alka, Leslie, Sean, thank you so much. Before we go, let me just thank the 23 world-class consulting and law firms that were represented today here as sponsors and supporters of the event. Greatly appreciated. And thank you again to all the panelists and to all of you for being with us today. We hope to see you again soon. Thank you.
Thanks, Bruce.
Thanks, Bruce. Good job.
Bruce, thanks, everybody.